Concurrent Resolution 3011. Madam Secretary.
House Concurrent Resolution 3011, your conference committee, Senator Hogue, Chairman, recommends that the Senate recede from the Senate amendments as printed on House Journal pages 1232, 33, and adopt further amendments and place 3011 on the seventh order.
Senator Hogue.
Mr. President, House Concurrent Resolution 3011 is a resolution that proposes to amend Section 2, Article 3 of our North Dakota Constitution, and that provision relates to the initiated measure process. A little history, Mr. President, about how this bill started out. It started out in the House, of course, and what it proposed was that if a initiated measure was going to have a fiscal impact of $20 million or more, it should be on the general election ballot rather than the primary ballot. That's the way the House passed it. When it came over to the Senate, we amended the bill, and we amended it to say that we really shouldn't have a flat dollar amount in the Constitution, so we changed it from $20 million to $40 million, and we put an index clause in the provision as well, so that the substance of the provision at that time, when we passed it in the Senate, was that if it had a $40 million fiscal impact, inflation adjusted, that those measures would have to go on the general election ballot. What we did in conference committee, Mr. President, is we combined two ideas that we in the Senate and the House has passed concerning the initiated measure process. And so the other part of what we did to the bill in conference committee is, if the chamber will recall, we also passed a measure that said if a initiated measure has a substantial fiscal impact, and the figure we chose was $50 million inflation adjusted, that there would be some review of those large spending measures. Well, the conference committee discarded that concept and simply said, because we have the ability as a legislative assembly to review initiated measures if they are statutory through a 2/3 vote, we really didn't, as a legislative assembly, need to look at those initiated measures. So what we did is simply clarify that for constitutional measures, constitutional initiated measures that would appropriate dollars for a specific purpose, we said that those types of initiated measures could not be circulated for petition. Now, what we did, Mr. President, is we sort of shadow box with all of the various initiated measures that have been proposed over the past 4 years. And we came to the conclusion that under this provision, all of them would still be able to be circulated, and the intent of the people who circulated, their intent could still be met. But what the policy we're trying to avoid with the House Concurrent Resolution 3011 as amended is we're trying to avoid, one, putting large spending measures on the primary ballot, and two, putting spending continuing appropriations, embedding that within the Constitution. We think the policy is, if you're going to propose a measure that spends money on a continuous basis, it should be a statutory measure. So those are the changes, Mr. President, that the conference committee recommends on 3011, and it passed on a vote of 5-1, and we recommend that the full Senate adopt the conference report.
Any further discussion on the conference committee report? Senator Andrist.
Mr. President, I have a question for the carrier.
State your question, please.
My question for the carrier is mostly theoretical. Could an initiated measure deal with a policy that required an expenditure but didn't set forth what the expenditure should be, would leave it in the hands of the legislature?
Senator Hogue.
Mr. President, I'll need to ask for clarification. Do you mean if a measure said we have some objective, we don't know how much it's going to cost, but we expect it to be implemented by the Legislative Assembly?
Senator
Yes,
Andrus?
that's generally my question. As a for instance, could it say that the legislature shall create a heritage fund to be invested in conservation purposes? And if it didn't specify the amount, then would it be permissible under this legislation?
Senator Hoag?
Mr. President, yes, I believe that it would. And the example, Mr. President, that we talked about the most wasn't the Heritage Fund, but it was the old Measure 2 from the 2010 general election ballot, where we had a measure which prohibited or banned all property taxes, but then at the same time it obligated the Legislative Assembly to appropriate money to all the political subdivisions to meet their budget and operational needs. Now, under this provision, that measure would still be permissible, except it could not direct the legislature to appropriate that money, but what they could have done is say, we're banning property taxes, and you have to authorize political subdivisions to have the ability to raise revenue for their operational expenses. Currently, Mr. President, for example, we limit the amount that cities and counties may impose in terms of sales taxes. And that measure could have said, you must permit, we're eliminating property taxes, and you must permit the political subdivisions to substitute that loss of revenue with whatever source of revenue they choose to impose, either through sales taxes or other forms of taxes. The example that the question from the senator from District 2 would also be permissible, as long as we're not embedding a stream of spending in the Constitution. So that would be perfectly acceptable.
Senator Axness?
Mr. President, I have a question for the carrier, and the question is, I'm wondering if the conference committee at all discussed these pretty sweeping changes with the Secretary of State at all, and if so, what was his opinion on putting this into the Constitution?
Senator Hoag, do you wish to answer the question?
I do. We did not discuss it with the Secretary of State. Frankly, we regard this body as the policy-making branch of government, and the Secretary of State is somebody who implements that policy, Mr. President.
Any further discussion? Senator Dodson-Rod?
Thank you. Excuse me. Thank you, Mr. President. And also, I have a question for the carrier, and that is the voters approved the legacy fund at the ballot, and it amended the Constitution and set aside 30% of the off the top of oil revenues. If this measure had been in place at the time, would that have been a permissible measure? Could the voters have done such a thing? Would they have been able to have the opportunity to vote on that if this measure was in place? And then I guess the second question, if at some future time their initiated measure would come forward to designate a purpose for the funds that are in the legacy funds, would that be permitted under this provision?
Senator Hoag, do you wish to answer that question?
Mr. President, I'll try. I think there was two questions. The latter one I don't think would be permissible. Again, if you are going to put a measure on the ballot and you're proposing to amend the Constitution to generate revenue from some form of taxation, and at the same time you want the legislature, and because only the legislature can appropriate money, you want them to appropriate it, as it says, for a specific purpose, that would not be permissible. On the other hand, if you decided that you wanted to put that in statute, you wanted to create a heritage fund in statute, and you wanted $100 million for a heritage fund, that would be perfectly permissible. With regard to the legacy fund, a little history, Mr. President, that was not a initiated constitutional amendment. That was a resolution that this body passed in the in the 2009 Legislative Assembly, and then we put it on the ballot for the people to vote on.
Further discussion? Any further discussion? Senator Sinner.
Mr. President, question for the carrier regarding who makes the determination on whether or not an initiated measure can go forward if it's brought from the people. Is it the Attorney General's office? Is it the Secretary of State? Who says that those are legitimate constitutional amendments?
Senator Hogue, do you wish to answer that question?
Mr. President, we're not changing that process. What happens presently under our Constitution is the first thing that has to happen is that the sponsoring committee, and typically it could be 25 people, they will go to the Secretary of State, and before they can start circulating petitions for an initiated measure or for a referral, they have to get it in the proper form. It's got to the text of the measure has to be summarized by the Secretary of State, and he's got to make sure that that summary is a fair representation of what's in the actual measure. And once he does that, then those petitions are approved for circulation. The Attorney General under our Constitution has to be consulted, and that process happens up front. One of the things we liked about this measure is that if a group was aggrieved by this change, the benefit of this is that they will always be able to challenge that up front to the North Dakota Supreme Court. So they don't have to go through the effort of gathering signatures only to find out that the Secretary of State or the Attorney General doesn't agree that it's a constitutional measure. So that's the other benefit. The challenge, if there is a challenge, is up front before the signature gathering goes on.
Further discussion? Hearing none, the question is on the adoption of the Conference Committee report on House Concurrent Resolution 3011. As many senators as are in favor, please say aye. Aye. All opposed say nay. Nay. The ayes have it. The resolution is adopted. Yeah, switching down to the 14th order, still on House Concurrent Resolution. Madam Secretary.
House Concurrent Resolution 3011, a concurrent resolution to amend and reenact Section 2 of Article 3 of the Constitution of North Dakota relating to the fiscal impact of measures to initiate constitutional amendments and to the placing of initiated measures on the ballot.
Senator Hogue.
Mr. President, I believe I've explained the provisions of the bill, but I did want to talk a little bit about the policy behind it. Mr. President, I firmly believe we are the policy-making branch of government, and one of the things that I've always been concerned about is we just, as a body, we don't do enough strategic thinking. We're always concerned about the biennium and balancing the current budget, but we don't look out into the long term. And that's our constitutional charge, Mr. President. This measure does that. We talk about what are the things that could derail this economy that we have today. Certainly we know the price of a barrel of oil could do that. We know that commodity prices could do that. We know that the federal government's continuing cost shifting on things like water projects and Medicaid funding could do that. And all of those things are beyond our control, every one of them. Here's another issue that could derail our economy, and that's the idea that we have a surplus, and when you have a surplus, there are lots of people who have lots of brilliant ideas of how to spend that money. And this is something that this body can do to help shape our long-term prosperity. And so that's why I support this measure, and that's why I think the Senate should adopt it, Mr. President.
Further discussion? Senator Schneider.
Mr. President, just very briefly, I think with all the constitutional measures we're putting on the ballot, when voters get their ballot, it's going to look like one of the Dead Sea Scrolls. I don't particularly like this resolution, Mr. President. I think the people have used the power of the initiated measure process very responsibly. In fact, the example cited by my friend from Minot Measure 2, which was actually during the June 2012 election, that went down overwhelmingly. And so I think that is a vindication and a validation of the people in the way that they use this power. So I don't think this resolution is particularly necessary. I do have every faith that the people will reject this, but on the other hand, why don't we just save them some trouble, save some ink, and just reject this today?
Further discussion? Hearing none, the question is on the final adoption of House Concurrent Resolution 3011. Because it is a constitutional matter, we will proceed by way of recorded roll call vote. Would the Secretary please open the key? All senators have voted. Any senator wishing to change their vote? Secretary, close the key. Final tally on House Concurrent Resolution 3011 reveals 29 senators voting yea, 18 senators voting nay. The resolution is adopted. Senator Klein.
Mr. President, may we be on the 17th